state perspectives on reasonable and prudent parent standards. At this time, I'd like to turn the presentation over to Christy Stankovich of the City Building Center for States. Please go ahead.
Hi, this is Christy Stankovich of the Capacity Building Center for States, and welcome to this afternoon's webinar. Before we get started, I'd like to go over some housekeeping items. This webinar is being recorded, and this webinar is interactive, and we will have one polling question for audience participation. The phone lines are muted at this time, but the audience will be able to ask questions towards the end of this presentation. You can ask your questions via the GoToWebinar chat feature, or you can address them over the phone. At this time, I will turn it over to Jennifer Marcelli, Program Area Manager of the Capacity Building Center for States.
Thank you, Christy. Next slide, please. Good afternoon, everybody. This webinar will provide participants with the opportunity to hear from those who have experience working with the Reasonable and Prudent Parent Standards. I will now go over the agenda. Next slide, please. First will be introductions of our featured presenters, Tymothy Belseth, Young Adult Consultant, Amanda Williams, Foster Parent, Stephen Pennypacker from Partnerships for Strong Families, and Matt Hudson, the Youth Program Area Manager from the Center for States. We will go into more detailed introductions in a few minutes. Next, we will provide a brief overview of the Child Welfare Capacity Building Collaborative and the Center for States. We will then look at the PL 113-183 RPPS legislation and what it means. Following that, we will hear from our panelists as it relates to foster parent and social worker perspectives regarding implementation, successes, and challenges. Finally, we will open it up for questions and answers. I will now turn it over to Matt Hudson.
Hi, thank you, Jennifer. And so, as was mentioned, my name is Matthew Hudson. I'm the Program Area Manager for Youth Development for the Center for States. So I oversee the national priority areas focusing on older youth transitioning out of care. And then I also work on developing with consultants and the Children's Bureau our national youth agenda. Jennifer Marcelli, who you just heard from, is the Program Area Manager for Foster Care and Permanency. She has similar responsibilities for those national priorities and national agendas for that area. And she also then is that manager for the Family Empowerment area for the Center for States. You'll first hear from Tymothy in a few moments from Tymothy Belseth, who's one of our Young Adult Consultants. Our Young Adult Consultants is a program through the Center for States to engage alumni from foster care across the country in both the on-site work that we do with states as well as in development of products and services and work with our constituency groups. They also attend conferences on behalf of the Center for States as well. A little later, you'll also hear from Amanda Williams, who's a foster parent in North Central Florida, as well as a licensed clinical social worker, and overall just very powerful and engaging advocate for this work. And then also Stephen Pennypacker, who's the CEO for the Partnership of Strong Families, which is a community-based child welfare agency in North Central Florida, and which Florida is a state that has already implemented their reasonable and prudent parenting standards. So that's who you'll be hearing from in terms of some of the implementation successes, challenges, and general information that we'd like to highlight on this webinar today. Before we get too far, I'd also like to mention that on your webinar panel on the right, you'll notice there are 5 handouts. So we're going to start delving into information shortly, but I wanted to make you aware that you have access to 5 PDFs right now. And one of those is the PDF of the slides for this presentation. So for any of you who are thinking about asking if these slides will be available, they are available right now. And then also the Children's Bureau Information Memorandum on the legislation, as well as 3 documents that Stephen has provided around the law in Florida and normalcy as it relates to some guardian ad litem aspects. So I just want to make you aware that those are there if you'd like to look at them, and then you can ask questions about them later in the questions and answer period. Next slide. And so just to give you kind of another frame, our objectives for this webinar today are that you understand the relevant legislation. And we had a webinar about 6 weeks ago that was just on legislation, so it will be very brief today, but we do want to make sure that we give you an overview of what's relevant to RPPS. And then we also want you to be able to gain information on the implementation successes and challenges that the states that have implemented it can talk about. And then we want to make sure that you have the time to ask questions to our presenters who are so knowledgeable in the working with RPS aspect of this. And with that, I'm going to turn it back over to Jennifer Marcelli. She's going to give you a little bit more information about the Child Welfare Capacity Building Collaborative in the Center for States.
Thank you, Matt. As Matt said, I'm going to give you some information about the Child Welfare Capacity Building Collaborative and then some information about the Center for States. In October 2014, ICF was awarded a contract by the U.S. Department of Health and Human Services Administration for Children and Families, the Children's Bureau, to establish the new Child Welfare Capacity Building Collaborative. On the next slide, you'll see the Center for States, the Center for Tribes, and the Center for Courts are partners who form the Capacity Building Collaborative that consolidates services that had previously been provided by National Child Welfare Resource Centers. This consolidation increases coordination, leverages resources, and provides more strategic service provision. On the next slide, you'll see that the goals are to work with partners and jurisdictions to support capacity building to lead to improved outcomes for children and families. We do this by partnering with states, territories, tribes, and courts to identify, design, and implement innovative solutions that meet the unique needs of each jurisdiction. The next slide will introduce you to the Center for States. The Center for States serves state and territorial public child welfare agencies and Title IV waiver demonstration jurisdictions. ICF International supports the Center for States, where Maggie Bishop is the project director. You might recognize ICF from our work with the Child Welfare Information Gateway, as ICF has a long history of working on technical assistance contracts with the Children's Bureau and other government agencies. The Center for States aims to provide evidence-based capacity building support services that will improve performance and support states and territories in effectively initiating, implementing, and sustaining change and innovation. To achieve this goal, we will work with our partners to create and deliver coordinated, inclusive, and well-informed capacity building services. Now that I've given you that brief introduction to the Capacity Building Collaborative and the Center for States, I will turn it back over to Matt.
Thanks, Jennifer. Going to the next slide. Yeah, so here, and again, as I mentioned, I'm just going to give you a really brief overview of 5 parts of the PL 113183 law that relates to RPPS. I'm just going to be reading definitions from you, so I want to mention 2 resources. The first is, again, you have a handout available to you through your webinar panel. It is the Children's Bureau's information memorandum on the law, which summarizes some of the information. Then also you'll notice on the slide that there's a link to the actual legislation where I'll be reading my definitions from. So if you open the handout that is the PDF of the slides, you'll be able to access that link. So the first is the definition of reasonable and prudent parent standard. And that is, per the legislation, the standard characterized by careful and sensible parental decisions that maintain the health, safety, and best interests of a child, while at the same time encouraging the emotional and developmental growth of the child, that a caregiver shall use when determining whether to allow a child in foster care under the responsibility of the state to participate in extracurricular, enrichment, cultural, and social activities. Next item is how the law defines age or developmentally appropriate, and that is activities or items that generally accepted as suitable for children of the same chronological age or level of maturity, or that are determined to be developmentally appropriate for a child based on the development of cognitive, emotional, physical, and behavioral capacities that are typical for an age or age group. Next. The first item is definition of caregiver. Again, under the legislation, it is a foster parent with whom a child in foster care has been placed or a designated official for a child care institution in which a child in foster care has been placed. Next bullet is that I wanted to read some of what the law says are activities such as. So this is just an example of some activities that are specified in the legislation. It says activities such as whether to allow the child to engage in social, extracurricular, enrichment, cultural, and social activities, including sports, field trips, and overnight activities lasting 1 or more days, and to decisions involving the signing of permission slips and arranging of transportation for the child to and from extracurricular, enrichment, and social activities. So I do want to highlight before I move on that this is just a list of some examples, that it is not inclusive, say, of everything that might be an activity that's developmentally appropriate. And then the last item is liability. And so there is specific language that is, the standards established shall include policies related to the liability of foster parents. And so I'm not going to get too much into what that means or looks like. Amanda and Stephen will do that here in a few minutes. But I did want to mention specifically that the law allows for the standard to include this information. And now I'm going to turn it over to our first presenter, Tymothy Belseth, a young adult consultant from Texas.
Thanks, Matt. Hello, everyone. My name is Tymothy Belseth. I am a young adult consultant. I also am employed with the state of Texas, and I'm here to talk to you a little bit about normalcy and some of the benefits that it might be able to bring about. I speak to this not only from working with youth over the past few years that I've been employed in Texas, but also as somebody who was in the Texas foster care system for several years as a teenager and aged out of the system as well. I don't see anything on the slides here, but what I'm going to talk about is, in this first part, is improving the foster care experience and the likelihood of increased well-being by providing normalcy. I think that it's critical that we change the way youth encounter and experience the foster care system, and I think it's also very important that we increase the well-being. You know, many of the three core elements of foster care is safety, permanency, and well-being. However, I think that normalcy is one of the means in which we can achieve a good sense of well-being amongst our youth. All too often we see many youth that have this very oppositional mindset, or they have this attitude that that people in foster care aren't doing the best thing for them. And when you talk to youth and you start to ask them, well, why do you think like this? Often what you'll hear is that they feel that foster care is too prohibitive, it's too restrictive, and that they want to be treated just like normal kids, and that the foster care system right now doesn't afford this experience to them. I think that providing normalcy is critical to make them think that they're normal children, because they are normal children. It's just unfortunate that their circumstances have led them into being placed in foster care, but that doesn't necessarily mean that we have to treat them as if they are infants, or that we have to restrict all of their activities because of fear of liability. And so I'm very pleased that we're seeing this effort nationwide with federal legislation and then state legislation in various states that are creating these waivers of liability and trying to promote these normalization experiences, because we understand that by having friends, by participating in extracurricular activities, by doing things like working and other age-appropriate activities, people start to mature and grow in a natural, socially developmental, appropriate way. So I think, can we go on to the next slide for mental health implications? So I kind of want to blend the mental health implications and well-being section together. I think that if you look at some research, and I've been able to pull some together, I don't know if any of this research will be available as a handout, but if you look at the things that you would consider normalcy or normalization activities, such as having and seeing friends, being able to go out and exercise, being a part of extracurricular activities, there are some real implications for mental health effects. I mean, if you look at some of the data out there, it shows that being able to confide in friends is one of the best non-pharmacological methods of improving one's mental health. It can stave off depression, it can reduce social anxiety, and I think that's critical, especially when we have many youth in care who suffer, unfortunately, from trauma. We all know that we cannot medicate trauma away, and I think that it's very important that we look at methods to help youth overcome this trauma that don't involve trying to give them medication. Furthermore, we know many youth view their treatment regimens as ineffective. They think that that the therapy or that the medication isn't really going to help them, and I think that that's really an issue when we wonder why their outcomes are so poor, or perhaps their situations deteriorate in foster care. Can I get the next bullet point? And finally, just to talk a little bit about the implications normalcy may have on outcomes, one of the things that I think is very important is that there's this push for permanency, and I think that that's great. However, I think that if there isn't a good sense of well-being prior to the push for permanency for, let's say, an older youth, I think that's sort of putting the cart far before the horse. If youth have an oppositional mindset and they believe that nobody in foster care wants to listen and act according to their interests, then they're going to hold on to this negative mentality, which I think will prevent any permanency efforts from achieving anything like adoption or finding the supportive adult that can be there for them once the youth age out. But there's also some implications for the general outcomes as well. You know, we're seeing a lot of research come out with the National Youth and Transition Database, but also intuitively, if you look at some of the programs and services that are offered to older youth at ages 21 through 22 with extended foster care and supervised independent living, one has to ask, why are the participation rates so low for this? I mean, we know that when youth age out at age 18, the likelihood of falling through the cracks and failure is very high. But when you talk to youth, you'll realize that many youth don't want to go back into foster care at age 18, even if they need help, because they've been denied this social development for so long, and they want it so badly that they're willing to fail and then not ask for help once they're in a bad situation. And I think that it's really a shame that there's so many youth who just want to immediately leave foster care so that they can go out and try to be a kid after they're already an adult. And I think that goes back to changing the way youth experience the system. We don't want to have a system that kids want to leave immediately whenever they get the first chance. We want to create a culture of understanding and trying to work with youth so that they can, have these normal experiences, grow just like any kid not in foster care would, and have a safe environment in which they can learn all those mistakes and natural consequences that are conferred in those teenage years. And I think that's by providing normalcy, I think you'll see some better outcomes in general for youth in care. And I think I'm done here.
Great. Thank you so much, Timothy.
Sure.
And so we're going to go ahead and move on. We're going to do our first poll question. Which is, has your state adopted a reasonable and prudent parenting standard? You have three options you can choose. Yes, we are implementing. Yes, but we are not ready to implement yet. Or no, not at this moment. And we're going to go ahead and give you about 30 seconds to go ahead and answer the poll, and then we'll close down and see the results. It'll help kind of give perhaps a landscape of who in the audience is working to Amanda and Steve.
And hello, Matt. This is Christy Stankovich. I realize that we've received a couple of emails that the GoToWebinar platform is having some technical difficulties, so keep trying those links, but we'll be sending out the PowerPoints and the handouts shortly so that everyone can follow along. But I realize not everyone can see the polling question at this time.
Okay, great. Thank you. So if you can't see it, go ahead and answer. We'll give just a couple more seconds. Okay, can we go ahead and see the results? Okay, so awesome. So we have 56% say that yes, they have the RPPS and they are implementing. 24% yes, but we are not ready to implement. And then 19% no, not at this moment. So great. Thank you very much for your participation. And at this time, I'd like to move to our kind of primary discussion, which is reasonable and prudent parenting standards implementation discussion. With that, I'd like to now reintroduce Amanda Williams and Stephen Pennypacker from Florida, and I will let them talk a little bit more about themselves.
I'll go ahead. This is Steve Pennypacker. I'm the CEO of Partnership for Strong Families, and as Matt said at the beginning, we're the lead agency for community-based care in Florida. If you don't know, Florida has, by law, privatized the foster care and adoption piece of the child welfare system. So after the Department of Children and Families has done the investigation and brought the child into care, we pick it up in the private sector. And we cover 2 judicial circuits in north central Florida. That's actually 13 counties. So in my duties in child welfare before this, I actually am an attorney. I worked as a magistrate at one point, hearing dependency cases. I worked for Children's Legal Services representing the department in court, and I was the program secretary for the Department of Children and Families. During some of those hats, was at the time in 2013 when Florida actually adopted the Reasonable and Prudent Parent Standard. It was driven mostly by our Guardian ad litem program to get it through the legislature, but the department obviously had input into the statute as it was being created. And one of the things that you can see in our statute, I know liability is an issue for everyone, is the balancing that we had to do to put that provision in. You know that, as Timothy just said, many people who are caregivers are very reluctant to have a child take part in activities because they're afraid of something bad happening. And so when we passed our statute, we were careful to balance it, not to change any existing common law or tort requirements that may be in the law, but to say if you do it as a reasonable, prudent parent and something goes bad, you should not be held accountable as long as the decision you made was appropriate. So it's kind of the background that I have going into it. The hat that I wear now as the CEO for the Community-Based Care Agency is to make sure that we pay attention to our partner families, that's what we call our foster families, as well as our relative and non-relative caregivers and our group homes, that they are implementing the statute and that our children are getting the opportunities that they should be allowed to have. And I'll hand it over to Amanda.
Hi, my name is Amanda Williams. I'm a foster and adoptive parent in Gainesville, Florida, and I get the pleasure of working with Stephen often. I foster and adopt only teenagers, so it makes the normalcy laws and prudent parenting very important for us. All of our teens are typically, well, as many teens, the quote-unquote difficult to place, lots of frequently behavior issues, lots of family attachment, and kind of working with prudent parenting and seeing it almost as a co-parenting role with the family care counselor, with the birth family, and the teenager themselves. And I think one of the things, both in my introduction and as we talk about this topic, is to acknowledge that it is very hard to go from a very traditionalist, old-school approach of fostering and then start looking more at prudent parenting, having the foster parent take on more of an active role. So for those states, that percentage that hadn't really started rolling it out, you have to have your foster parents on board. I also work with the Foster and Adoptive Parent Association in Florida and have really done a lot around prudent parenting with them and how can foster parents be as on board and as knowledgeable as possible, and sometimes even help train and educate those middle managers and the direct care workers who may or may not be as knowledgeable with the direct law and exactly how it's going to work in practice.
So one of the things that we get asked, especially where I sit, is, can you just give me a list of the activities that you will allow us to do and the ones that the children can't do? And obviously, you don't want to do that, because if you look at the definition of reasonable and prudent parent, you can see that the intent of it is that that person, that decision maker, is to make those decisions based on that individual child. So you're looking at that child's cognitive and educational capacity, their maturity, what their past experience has been, what their physical capacity could be. So a simple example I like to give is that, a child comes to you and he says he wants to play football, and he's 5'1" and he weighs 120, and he wants to go out for varsity football. Unless he's going to be a place kicker, probably not a good idea. But that doesn't mean he can't do other activities. His desire to play is probably very strong, but you as a reasonable and prudent parent would probably be saying, I don't think so, let's wait until you get a little bit bigger to be able to play football. So again, it's a child-by-child decision. There's not an automatic list to say, yes, you can do this, yes, you can't. And another thing I wanted to emphasize is that when you have that decision maker, the intent of the statute is that you're taking it away from the case manager and from the court and even from the guardian ad litem, so that it is the person who the child is staying with. That's the person that's been given the authority to make those decisions. So we want to make sure that it's emphasized that way, so that the caregivers are not always turning to a case manager or going to court and getting permission to do things, because that delays the ability of the child to take part. As Timothy said, kids that are able to lead a more normal life are going to do much better. We're not putting their well-being on hold just because they're in out-of-home care until they reach permanency. Well-being does not stop just because a child's been removed and they're in out-of-home care.
I think one of the important things that we do in our area and that Timothy pointed towards is that you have to have the youth at the table. When you're talking about prudent parenting, when you're talking about normalcy, it's not done in a vacuum. It's not the foster parent deciding this is what's normal. It's sitting down with your child and saying, what are the things you'd like to do, and where can we meet in the middle? And a lot of it is about trust. And when a child first moves in, our very first night, we have long discussions about our rules, our expectations. We are a foster home that expects a lot of work and a lot of advocacy, because we're big advocates. We travel the state. We travel the country kind of talking about these issues. And if a youth comes into our home that doesn't really care, this probably isn't the right fit for them. So normalcy is also understanding where is the right place for these teenagers especially, but getting their engagement and their involvement in the topic. One of our rules has always been that cell phones aren't allowed in bedrooms. You can have a cell phone, depending on your grades. Sometimes we'll even pay for it, but it doesn't go in your bedroom. We had one teenager move in where he had a lot of trauma. He had a very difficult time sleeping, very difficult time self-regulating emotion, and he asked to use his cell phone for music to do that. We talked about it for hours, because that was definitely against our rules or what our expectations were, but he actually came up with the idea to take out the SIM card and keep just his cell phone with music on it. It was a great idea. We were able to negotiate. It was the perfect idea of normalcy for us, that he could do what he needed, but our rules were still being followed, and every caseworker, everyone was on board with that idea, and it was a very supportive process.
So I'll go back a little bit, and when I said earlier that we try not to give a list and say these are activities children can do, we do get asked, okay, well, how do I know? What am I looking at when I get asked? So for a simple example, the child wants to go spend the night with a friend. In the past, we would have probably said, gee, that's not a good idea. We've got to run a background screen because this is a frequent visitor or a visitor at another home, and we don't know who's in that home. And if there's somebody bad in that house, then we let the child go, then we're all in trouble. So, that kind of an activity, you have to look at it as you would your own child. So if you're a parent that wants to meet the other family before you let your child go spend the night, then that's what you should do. If you're a parent that says, okay, I trust this child and I think they've got good judgment and I think it's okay for them to go, then you would let them go. I take it back to my own parenting. My kids are obviously older now, but as we were making those decisions, I kind of told them, I'm going to let you make decisions, we'll make them together jointly, but as long as there are no bad outcomes for these, I'm going to continue to let you do things. So as soon as you step up or you make a mistake and something doesn't go well, then we're going to have to rein it back in. Another way to kind of look at it when you're in the agency position or you're a case manager or somebody else that has to have these discussions, I like to look at it from the standpoint of what you would do if you were co-parenting and you don't live together as parents. So whether it's a divorce or any other situation where you still both have the obligation and the right to do the best thing for the child that is your child, you would want to confer with that other parent. So what decisions would it be that you would want to both confer with the other parent, or if the child's with the other parent, would you want to be conferred with before they do something? So a simple standard, again, I like to look at is if it's going to be something permanent. So I think back to having been divorced and having had a 14-year-old daughter that came to me and said, I want to get a tattoo. And I said, let's talk to your mom about that, because I knew I didn't want that to happen. And when I talked to mom separately before we talked to the child, we both agreed. Now, had we not agreed, then we would have had to work that out as parents, but it's just an illustration of something that was going to be a permanent change to the child that should have been a decision that got made by us jointly. So taking that same kind of standard, and one of the things we look at in some of the guidance you saw that we put up there from the Guardian Ad Litem program is haircuts. What kind of a haircut is the child going to be allowed to have? You don't need parental permission to do that when the child's been removed from out-of-home care, but you also are probably not going to want to have a child get something that's going to cause them problems at school or cause some kind of social issues just because they want to do that. So again, a reasonable and prudent parent would say, are you sure you want to do that for a child? It's not permanent. So if it is a learning experience, as Amanda said, or as Timothy said, let them experience these things so they can learn to make mistakes. You may let them get that mohawk that people are going to say, you're an idiot, why'd you do that? Because it's going to grow back. It's not permanent. So that kind of a standard to say what is the activity they want to take part in, as long as it's not going to do something permanently negative to them, then you might want to let them take the risk. So again, just kind of guidance when people are asking. I did write down a couple of things that I thought, as a reasonable and prudent parent, I probably would not let my child do, and maybe I'm more restrictive, but I don't think I'm going to let him go skydiving. Me is probably not going to let them ride a motorcycle just because I think they're too dangerous. I would not let them go rock climbing when it's free climbing. So if they want to go off in the mountains and they don't want to take ropes and those kind of things, not going to happen. I probably would hesitate to let them do it even with the ropes and the carabiners and those kind of things. Another activity that I think is probably going to be something depending on where you live, but here in north central Florida would be hunting. A lot of people hunt here in our area, many of our counties. That is a reasonable thing to do. So depending on that child, depending on the caregiver and their ability to do that activity safely, it can be dangerous, but done in the right circumstances, also very beneficial for a child to take part in that activity. The parents may not like it, the court may not think it's a good idea, but that reasonable and prudent parent can say, this is an activity that benefits kids. It's a growing experience. The child's got the cognitive capacity. I trust them. We're going to do it together. I'm not letting them go off by themselves, but I can make that decision, and we're going to do it. Very dangerous, can be very dangerous, but also has a benefit. So just throw those kind of guides into it in that thought process as you are getting asked, how do you coach people to make the appropriate decisions. Take it back to, if it was your child, what would you do? Because it really is your child. And if you had to have another parent make the decision with you, would you talk to them about it before you would make the decision? If that's the case, then you need to apply the criteria to the decision you make and the permission you give or deny to the child.
And this is Matt Hudson. I want to apologize again. I think we may be having some issues with the slides, but I kind of wanted to maybe ask a framing question for Stephen and Amanda for you. It's more about maybe some of the challenges of your working with the reasonable and prudent parenting. So along the lines of what you talked about, so Stephen, from the agency standpoint, have you had any issues with the foster parent liability? And then from Amanda, have you had any fear of not letting one of the youth that you've had in your home do an activity because of liability? And I was also wondering if you could also frame that in terms of working with the younger children rather than as well as just older youth in care.
We obviously have foster parent liability issues, but the cases that have made it to me have not been as a result of the decisions made by caregivers in the reasonable and prudent parent context. It's usually something else that's come up that creates liability. So I have yet to have a case come to us where a child got hurt doing something and the liability became an issue because, again, kids are going to get hurt. If they go skateboarding, they're probably going to fall. They may break an arm. But they would do that whether they're with our caregivers or not. If they play football, they're going to probably get hurt in some way. Kids can get hurt doing band. They can fall down and twist an ankle and do those kind of things. But to answer your question, no, we really haven't had any liability issues so far, and I guess it's a knock on wood, because of the reasonable prudent parent standard having been put in place.
And that is interesting that you bring it up. So all of our children are required to participate in an extracurricular activity. That's just part of being in our home, and they learn that the first day that they move in. And so one of our children, we actually have a 12-year-old right now, and she's doing track. And the track program that she's in has had lots of different foster kids through it. So they are very used to, getting either a court order or something from the family care counselor saying that this child's allowed to do it. Well, they haven't had anyone since prudent parenting went into effect. And I went to enroll her and wrote, foster parent and all the other things on her form. And the agency themselves wouldn't allow her to enroll until I got something from the FCC. So instead, I printed out the law and took it to them and said, no, she's allowed to enroll. This is the new standard, and you guys will get to work with me. That probably wasn't the best way to start our relationship, but so I do think that it is interesting when it comes to younger children, and even though it isn't all about the teenagers, but a lot of them, what's normal and reasonable to them isn't what will be normal and reasonable to a foster parent or an FCC. And I think it's important to remember that prudent parenting and normalcy does not mean that the teenager or the child just gets to do whatever they want to do. It really is about that negotiation and kind of working together to come up with a plan that will help for their growth and development. And that's the important part for any age range. And it's funny that Stephen shared the Mohawk story. Our 12-year-old, who's a girl and had beautiful long hair when she moved in with us, had always wanted to have a Mohawk, had never been allowed to. So we did make her write a contract to herself, and every day she had to sign it that she still wanted a Mohawk. And so after 30 days of wanting one, she sat down with her mom and told her mom she wanted a Mohawk, and the next day she got a Mohawk, and she's loved it. It's funny, it's going on 3 months now, and she keeps getting the Mohawk cut every single time.
I was going to say, too, Matt, in terms of age, thinking back to the social media and the cell phone that Amanda mentioned, I'm shocked, and I know it's just because I'm older and we didn't have cell phones when my kids were growing up, but to see what looked to me to be 7, 8, 9-year-old kids that are walking around with cell phones, I'm not sure that that's a good idea. So if our reasonable and prudent parents are coming to us and saying they want a cell phone, they're in second grade, I think it's reasonable and prudent to say, no, you're not going to get a cell phone in second grade. One of the issues that comes up is babysitting. So at what age can a child either be a babysitter or be babysat for? And again, there is no bright line rule for that. We generally say 14, 15 is old enough to be a babysitter if they take the babysitter training. But again, what would you do as a parent? People will say, well, you can't leave a 10-year-old alone. Well, you probably can't, depending on the 10-year-old. You may have a 10-year-old that is mature enough to be able to handle 15, 20 minutes away. People may go, 10 is never old enough. There is no 10-year-old that I would leave alone. But there's also some 15-year-olds that you're not going to leave alone. So kind of going back to it, I don't think the age is necessarily the criteria. It's the activity, and is that particular child have the maturity and the decision-making to do whatever it is they're wanting to engage in. So, again, what would you do if it were your child? That's what you should be applying to that case.
Great, thanks. I think we have a few more minutes. If you guys had any other kind of still maybe focusing on these challenges, or if you wanted to identify, some of the prominent successes, but any of the kind of detailed challenges of working around the nuances of this, Stephen, from that agency perspective, is there any way that you look at, say, what is the relation? You mentioned earlier that the court may not necessarily like something or a worker in the past, but you said with the reasonable and prudent parenting, it transfers to that. Can you maybe explain a little more about what you mean about can a reasonable and prudent parent prohibit a court order, or what is the interplay between the other entities and child welfare that are still relevant? And then again, Amanda, any experience that you might have similarly?
Here's an example. It was common in Florida to have boilerplate language in orders once a child was brought into care that say the child cannot be removed from the state of Florida without a court order. Sometimes that would be modified at the beginning to say cannot be moved for more than 2 weeks without a court order. And so prior to the standard, that would mean if the child wanted to go across state lines to go to Wild Adventures, which is a theme park in southern Georgia, and they may live in Tallahassee and it's an hour ride. Sorry, can't go. It's across the state line. Every other kid gets to go, but you got to stay home because we have a court order that says can't travel outside the state of Florida without a court order. Hopefully now those kind of things, those boilerplate, I'll call them rigid policies that were transferred into court are coming out so that our orders don't say that anymore, that a child can go across state lines if it's an appropriate thing to do without getting court permission. If you wanted to send them to Europe, you probably might want to talk to the court about that. But again, reasonable and prudent parent may say that's okay. If you ask me, I would ask that we do go to court before a child left the country, even if it's just for a day visit. Now, people in Southern California or Texas may say, hey, we go across the border all the time. That's ridiculous. They shouldn't have to go to court to do that. I just look at it from where we are, but that's the kind of standard. So, again, case managers should not always be the decision makers for kids. The reason we put this in is so that those day-to-day decisions don't have to be made. I mean, again, silly examples to put it on one end of the spectrum. Can they eat Cheerios as opposed to whole wheat cereal or grain cereal? Are they allowed to have bacon? Can they drink Coca-Cola because it's high in sugar? You got to let people make those calls. That's not something that either the guardian or the court should be weighing into. But by law in Florida, at the other end of the spectrum, if a child's going to have surgery or they're going to have a termination of a pregnancy or something like that, that's absolutely got to go to court. That is not something that's within the reasonable and prudent parent standard. So, again, those are permanent decisions that affect the child. That's not something you can just do on your own.
Great. Amanda, anything before we move to questions?
I think that there has been a direct change in Florida of how the FCCs empower foster parents. And I think when we're looking at implementation and when we're looking at rolling out a new program, the most important part is actually empowering each group and making sure that they know what the expectations are, having checklists, having an idea of what are the types of questions to even ask a foster parent, and having trainings for each different area, both separate and together, so that FCCs, foster parents, and even the teenagers are empowered and understand what their rights are. Often I get new FCCs out now that don't fully understand what I can do and what I can't do, and they still have the old ideas from TV movies and things like that, where even for haircuts you have to go to court and go through this very long process that isn't true anymore.
And just to clarify, FCC is Family Care Counselor, so that acronym is
sorry.
That's okay.
Well, Amanda and Stephen, thank you so much. We're going to take the opportunity now to open it up for questions. We have two ways. A lot of you have already been asking questions through the question pane. I really appreciate that. A lot of good questions have come in. We also have the ability to take questions live. Christy, if I could ask, would you like us to start with questions that have been submitted, or... I'm going to take a pause. Yes, Jennifer, is there a question you want to pose from the question pool first?
Sure. Stephen, I'm wondering if you can answer the question posed about are relative care providers considered caregivers for RPPS purposes?
Yes. Yeah. In Florida, the definition of caregiver, and I've got it in front of me here, means a person with whom the child is placed in out-of-home care or a designated official for a group care facility licensed by the department under a statute. So that means every out-of-home caregiver, whether they're a relative, a non-relative, a licensed foster parent, a group home, anybody that's not the parent is going to fall under the caregiver definition, and the reasonable prudent parent will apply to them.
Great, thank you.
Great. And then we have another question is there more information about liability, sorry, my question pane is moving on me. What kind of liability insurance do you have? Does the state of Florida assist caregivers with this if necessary, and if so, please describe.
Amanda may know whether there's insurance available for caregivers. I know that our agency, we have general and professional liability insurance, so we would be covered for those activities if they're within that risk. I mean, if a foster parent does something that's outside of their scope, then I don't think our insurance is going to want to cover that. But, so we have our general liability policy would cover it.
Great.
Amanda, I don't know if you have an individual policy for a foster parent. I don't know if that's available.
I have never heard of one, and I don't think that that's something that foster parents are going out and getting. I think that there is a lot of agency concern about liability. I don't know how concerned most of the foster parents that I've trained with and talked to are not that worried about the liability. If they're told they can make these decisions, they make the decision.
Great. And I do, Jennifer's going to have another question in a second. We have so many coming in. I do want to take just a second to let you know that we will not have time to get to all of these questions, but that we will. All of the questions are recorded for us. We will have them after the webinar, and we will get you an answer to your question, whether it's some of us from the center or Stephen or Amanda. So I just wanted to let you know that. Jennifer, do you have another question?
Sure. Stephen, if you could maybe answer this question about liability, how have you addressed it in your policy or administrative rules?
Well, it's by statute in Florida, so, and again, I can read you what the statute says. It says, limitation of liability. A caregiver is not liable for harm caused to a child who participates in an activity approved by the caregiver, provided that the caregiver has acted in accordance with the reasonable and prudent parent standard. This paragraph may not be interpreted as removing or limiting any existing liability protection afforded by law. So the implementation, and what that means is that if you follow the standard, if something goes bad, as long as you made a decision that you're looking at all those criteria under the statute, that someone else would look at it and go, that was a reasonable decision, and you have a negative outcome, there should not be any liability. So we have not gone beyond that in terms of our policy or anything like that because I think the statute's clear. We were going to have someone from our central office on the phone. I don't know if she's able to chime in or not, but I don't believe we've transferred that into administrative code yet, but I know we just adopted a new code for foster care, and it may have made it in there by now. So I'd have to ask them if they're able to chime in. May not be able to do that since we don't have the lines open.
Okay. Thank you, Stephen. Amanda, one that maybe you might be able to speak to, can you talk about the social activities such as sleepovers, dating, and Facebook, which I think we can all agree are pretty heavily social, but also kind of have a lot of the interpersonal risk? I'd like to hear about perspectives on those aspects of the normalcy.
Absolutely. So I'm sure my teens would have a much different perspective on this than I do. I'm a very overly involved mothering parent, which is great for me, maybe not so much for them. But we do, especially at first, we have very frequent computer checks, and we let them know if you're not comfortable with me reading it, you shouldn't be saying it. So they are allowed to have Facebook. They're allowed to be on Facebook. I don't usually. It depends on safety plans, of course, and different youth have different requirements. But if a child doesn't have any internet requirements, they're allowed to get on their own, but they can't put passwords that I don't know. They can't have it where I can't log in. And then just kind of based on their behavior and my concern determines how often I check that account.
Great, thanks. Jennifer, do you have another one?
Sure. Does Florida have a set of questions or things to think about for individuals making prudent parenting decisions like you guys have been discussing?
We do. We have the Center for Child Welfare through the University of South Florida is a website anybody can go on, and some of the materials that I sent to Matt came from that, so they're going to go back out there. There's a lot more on there. and there is a set of frequently asked questions that is in there, so it's some guidance and kind of tells you what to look at. So I'd say, again, the Center for Child Welfare, University of South Florida, if you just type in reasonable and prudent parent in the search box, you will get several pages of materials that will give you some guidance.
Great. Actually, I wanted to let everyone know the Florida DCF Central Office person, Tori Wilson, is here and responded saying liability is not addressed yet in rule as it is clear in the statute. So I wanted to mention that. There are several questions about Florida's law and policy and statute, and so I want to again reference everyone to the handout area of the webinar platform. If you can't access it, the Let Kids Be Kids law, which should have all of Florida's RPPS statutes there in it, or at least a summary and description of it. So you should be able to access some of it there, and if there's something in there else that you need, we can try and get that for you. I think we have time for one more question, and I kind of want to paraphrase of what a few of them have addressed, and it has to do with whether it's cultural or religious activities or beliefs, or even just something like participation in sports. How does the reasonable and prudent parenting standard play with then what the biological parents who might still be involved feel is appropriate for their child as well?
Amanda, you want to take that one, or you want me to do it?
Sure, I can start. And so I think a lot of that is how we train our foster parents and how involved we are with birth families. And I think the number one goal, obviously, of child welfare is reunification, and that families should be working together on smooth transitions, on making sure that children feel normal and accepted both in foster homes, group homes, and then with the hope of going back home. With that being said, what we frequently do is we work with the birth parent to make sure that they're comfortable and that they eventually agree with getting the mohawk, with getting, all of the different things, and we walk them through our parenting process so that we're modeling to them how we parent. That doesn't always work, and sometimes a child feels like something is a cultural belief that they want to do, that we disagree that is a healthy cultural choice. And so when that's the case, that is our prudent parenting teaching them or telling them no. But it is sometimes a conflict, and there are, I guess one disclosure is that my wife and I are gay, and sometimes parents come in and they say that they don't want their children living with a gay couple, or they don't want different cultural events, I guess, that we go to. They don't want their children exposed to that. And it is our normalcy and our prudent parenting that the children attend events that we attend and that we go together. If that same child then wants to go to church on Sunday, we go to church on Sunday. So a lot of it is about meeting that child where they are and making sure that all of their needs are met.
And I would just add that, again, by statute in Florida, and the one place you can find it is Florida Statute 409.145. It's where a lot of the provisions are on the reasonable prudent parent standard. We have quality parenting by law in Florida, and one of the requirements is that we only place a child into a home where that caregiver is willing to accept responsibility and willing to learn and be respectful of the child's culture, religion, and ethnicity. So just as Amanda said, that foster parent should be working with the biological parents or the legal parents to say, these are the issues. Is there something I need to know about your culture, your ethnicity, your religion that's significant to you that should be significant to my care of your child? And have those conversations. So it isn't something now by prudent parenting, you now get to be the dictator and make that decision on your own. You need to be working with the parents, because hopefully if they're doing a reunification case plan, the child's going back home, and you don't want to undo or undermine anything that was in the nature of religious or cultural education by that biological family.
Great. Thank you so much, Stephen and Amanda. I don't think we're out of time for questions. I just would like to, before we move on to the next slide, I would like to reiterate that we have received all of your questions. I'm so sorry if we didn't have time to get to one of them, but we will get them answered for you after the webinar, hopefully within the next week or so, or sooner. We'll be able to get you an answer to any question that wasn't done so here. Also, I know that there are some technical difficulties with being able to access the handouts that I've mentioned. I apologize for that, but we will send all of those out to the participants as well. So if you unfortunately aren't able to access them while we've been talking, we will make sure that you have them afterward. But so to close up, though, we do want to let you know that we have the Center for States has some other upcoming resources related to the reasonable and prudent parent standard. One that we have is a guide on having the normalcy discussion in your state. We're working on the official title, but basically there was a White House summit in May that brought together, Stephen and Amanda were there on a panel as well. It brought together people from every state, and it had discussions around things like brain development and trauma-informed care, lessons learned like from Florida and California, and then also allowed the people to have discussions about, what discussions they needed to take back to their state, as well as working with what community agencies they might be able to work with to help to work on developing these normalcy procedures. So what we wanted to do as a center is provide states with who should be there, what should be the topics, what does the agenda look like, to have some kind of meeting to get that federal level discussion on these RPPS standards brought down to the state level. We're also going to be producing a guide on youth advisory boards and foster youth bills of rights, because in the RPPS section of the legislation there is also a requirement that the youth and foster care are provided with a list of rights when they enter care. And so there's a lot of work to be done around that issue, and so we will be producing a guide on both topics of youth advisory boards and youth bills of rights, but also that integration in how youth advocacy can be involved in that. And then, of course, as I mentioned, the webinar materials will be emailed to participants following the presentation. So if we can go to our last slide, I just want to give you guys the contact information for the people at the center who can get you answers to your questions. And that's Taffy Campaign, who is a Children's Bureau foster care specialist, or her email is there. Catherine Heath is the youth specialist at the Children's Bureau. And then myself and Jennifer, the program area managers for foster care and youth here at the Center for States. If you have information, you can definitely feel free to email any of us, and we'll be able to get that for you. And that includes, I don't want to speak for Stephen or Amanda, but if you would like to get their contact information, and they are willing to allow us to provide it, we can get you that too, in case you have a question you'd like to ask them directly. And with that, I would just like to thank everybody for attending the webinar. I know, like I said, some of you had a lot of questions, but please take the opportunity to go to this link. If you can click on it now, please do. If not, when the slides come in your email, you can click on it there, and then also we'll be emailing it out with the rest of the materials. So please participate in the evaluation. It'll help us be able to design our webinars better to make sure that it's a good experience for you as we continue to present information, not just on the reasonable and prudent parenting standards, but on other areas as well. So again, thank you so much. Jennifer, anything else?
No, thank you very much for your participation.
All right. And with that, that concludes this webinar. Thank you.